So welcome back, dear students. Today we are going to learn what is judicial review. You know the system of judicial review. Judicial review of administrative action has been inherited from United Kingdom. It is on this foundation that Indian courts have built the superstructure of control mechanism. Judicial review is developed by judges on case-to-case basis. What is judicial review? Judicial review is a review of government decisions done by the Supreme Court of India or by the various high courts. A court with authority for judicial review may invalidate laws and acts and governmental actions which violate the basic structure or basic features of our constitution. So dear students, judicial review, basically it refers to the power of judiciary to interpret the constitution and to declare any such law or order of legislature or executive as void if it finds them in conflict with Constitution of India. The most distinctive feature of United States Supreme Court is its power of judicial review. In our country also, our Supreme Court has power of judicial review, and similarly, various high courts also have power of judicial review. Now, what is the procedure of judicial review? You see, judicial review is governed by the principle of procedure established by law. As given in Article 21 of our Constitution, the law has to pass the test of constitutionality. If it qualifies, then it can be made a law. On the contrary, court can declare such a law as null and void. The nature and purpose of judicial review, dear students, is not to review of the decision of administrative authority, but rather it is for decision-making process which is to be reviewed. Therefore, Supreme Court cannot assume appellate jurisdiction and reappreciate the facts found by the fact-finding authority. This is not to be done in judicial review. Even Supreme Court cannot assume appellate jurisdiction, and Supreme Court cannot reappreciate the facts found by the fact-finding authority. There are mainly three principles of judicial review. Number one, the Constitution is the supreme law of the country. That means any order, any action of the government, any law passed by the parliament is subject to the Constitution. Because Constitution is the supreme law of the country, every law, every action of the government has to follow the norms written in our Constitution. Second principle is the Supreme Court has the ultimate authority in ruling on constitutional matters. Of course, the high courts too have power of judicial review, but the Supreme Court has the ultimate authority in ruling on constitutional matters. And third principle of judicial review is the judiciary must rule against any law that conflicts with the Constitution. If any law passed by the parliament, if it violates any provision of the Constitution, then judiciary must declare such a law as void or not enforceable. This power of judicial review over legislative action vested in the high courts under Article 226 and in the Supreme Court under Article 32 of the Constitution is an integral and essential feature of our Constitution, constituting its basic structure. You cannot change Article 226 or 32 because it constitutes basic structure of the Constitution. Simply put, judicial review is the power of the courts of a country to examine the actions of the legislative, executive, and administrative arms of the government and to determine whether such actions are consistent with the constitution or not. Or you can say, dear students, that judicial review is important because it is essential for maintaining the supremacy of the constitution. It is essential for checking the possible misuse of power by the legislature and executive, and it protects the rights of the people. It maintains a federal balance between the central government and the state government also. So, dear students, judicial review is the process of challenging the lawfulness of decisions of public authorities, usually local or central government. See, if a judicial review is successful, the usual result will be that decision is quashed or nullified. In turn, this usually means that decision has to be taken again by the authority because the decision was not in accordance with law. Now let us see what are the sources of judicial review. If we talk about American situation, then this judicial review was established by the landmark decision in Marbury versus Madison, in which it was said that no law or action can contradict the US Constitution, which is the supreme law of the land. And if any law or any action of the government, it contradicts with the Constitution, it can be judicially reviewed and cancelled. And in United States, you know, there are so many states and they have their own judicial system. So in USA, state courts also have the power to review state laws or actions based upon their state constitutions. If we talk about Indian position, then we have Article 13. Please open up your bare acts. We have studied Article 13 in earlier lectures also. This Article 13 of Indian Constitution in fact provides for the judicial review of all legislations in India, past as well as future. This power has been conferred on the High Courts and the Supreme Court of India, which can declare a law unconstitutional if it is inconsistent with any of the provisions of the Part 3rd of the Constitution. Meaning thereby, if a law contravenes fundamental rights, it can be declared as null and void, exercising the power of judicial review given in Article 13. Dear students, imagine what will happen if there was no judicial review. In the absence of judicial review, Constitution would be rendered unenforceable. If federal officials violated the Constitution, the only course would be in the political process, a process unlikely to offer protection to those whose rights have been violated. No protection will be available to the persons whose rights have been violated in the absence of judicial review. Now, judicial review can be done in our country by the Supreme Court. The Supreme Court's power of judicial review extends to constitutional amendments also. Parliament can amend the Constitution under Article 368, but such amendments should not take away or violate fundamental rights, and any law made in contravention of this rule shall be void in view of Article 13. You see the famous leading case, Keshwanand Bharati versus State of Kerala. It was held in this case that judicial review is not only an integral part of Constitution, but it is also a basic structure of the Constitution, which cannot be abolished or whittled down even by an amendment of the Constitution. So this judicial review is part of basic structure of the Constitution, which cannot be changed by the Parliament. So dear students, we have learned it in the earlier lectures also, that Supreme Court is invested with powers of judicial review under Article 32 of Constitution of India. Similarly, SLP, Special Leave Petition, Article 136, is also in the nature of residuary reserve powers of judicial review in the area of public law. Article 136 lays down that Supreme Court may in its discretion, grants special leave to appeal from any judgment, decree, determination, sentence, or order in any cause or matter or made by any court or tribunal. This is special power of the Supreme Court. And the first major case of judicial activism or judicial intervention by way of social action litigation or by way of judicial review was Hussain Ara Khatun versus State of Bihar. In this case, the right of speedy trial was recognized by the Supreme Court for those under trials who were in jail for a period longer than maximum sentence that could be imposed on conviction. Suppose I am detained in jail for theft and the maximum penalty provided under section 379 IPC is 3 years. But my trial is not finished and I am in jail for more than 3 years. So Supreme Court says under judicial review that there should be a fundamental right of speedy trial so that trial may finish quickly and it should not linger on for a period longer than the maximum sentence that could be imposed on conviction. So this is the first major case, an illustration of judicial review before you. Why it is called judicial activism? In India, it implies the authority of the Supreme Court and High Courts, but not the subordinate courts. Subordinate courts have no power of judicial review or to declare the regulations as unconstitutional and void if they breach or if the legislation is incompatible with one or more of the constitutional provisions. Subordinate courts have no power of judicial review or judicial activism. Only the Supreme Court, the Apex Court, and various high courts in our country, they do have the powers of judicial review or judicial activism. Now let us see judicial review by the high courts. That is under Article 226. This Article 226 empowers the high courts to issue directions, orders, or writs for the enforcement of fundamental rights and for any other purpose also. Thus, power of judicial review of high courts is wider than that of Supreme Court. Why? Because the words for any other purpose, as mentioned in 226, enables the High Court to exercise their powers of judicial review for the enforcement of ordinary legal rights, which are not fundamental rights, and for the enforcement of fundamental rights also. And the jurisdiction of high courts under Article 226 for enforcement of fundamental rights is mandatory, whereas for enforcement of ordinary legal rights, it is discretionary. But in both the cases, judicial review is done by the High Court under Article 226 of Constitution of India. So this power of judicial review, dear students, under Article 226 is a constitutional power. Therefore, no legislature can take away this power. High Court can issue a writ even when the person or authority is located outside its territorial jurisdiction, if the cause of action has partly arisen outside its jurisdiction. Suppose Allahabad High Court is hearing a writ petition and part of cause of action arose in Noida and partly the cause of action for the writ arose in New Delhi. So Allahabad High Court has power to issue writs even to those respondents who are not resident within its jurisdiction, they are residing in Delhi. Still, Allahabad High Court has power of judicial review over those respondents because the partly cause of action arose in Noida and partially the cause of action arose in Delhi. And dear students, you must note it that power of judicial review is supervisory and discretionary in nature. And this power cannot be exercised as a court of appeal. While sitting as court of appeal, the powers are different. But while sitting as court exercising writ jurisdiction, the powers are different. Okay. The power of judicial review under Article 226 is not directed against decision. No, but it is confined to the decision-making process. Court, while judicially reviewing the matter, will see whether the lower authority has followed the decision-making process prescribed by law or not. If not, then action of the government will be struck down. Then, dear students, High Court, being a court of plenary jurisdiction, has inherent powers to do complete justice between the parties, similar to the powers of Supreme Court under Article 142. We have a landmark judgment, L. Chandra Kumar versus Union of India, decided by the Supreme Court in 1997. Supreme Court held in this case that the power of judiciary over legislative action vested in the High Court under Article 226 is a basic feature of Constitution of India, and therefore it cannot be ousted or excluded even by way of Constitutional Amendment Act. Accordingly, Supreme Court declared Article 323 capital A 2D and 323B 3D, which were added by 42nd Constitutional Amendment Act, as unconstitutional. Why? Because they excluded the jurisdiction of the high courts under Article 226 and 227. These two articles authorize the Parliament to establish special courts or tribunals to perform substituted role of the High Court, meaning thereby by this amendment, the jurisdiction of the High Court was taken away and jurisdiction was given to tribunals. And in 1985, the Administrative Tribunal Act was also passed and service tribunals were established, as all of you know. By this Administrative Tribunal Act of 1985, the jurisdiction of high courts over these tribunals under Article 226 and 227 was taken away, as these tribunals had been given substituted role of the High Court. So according to ratio decidendi of L. Chandra Kumar, the power of the High Courts under Article 226 and 227 has been restored. This additional article added by 42nd Amendment Act have been declared as null and void. Now, dear students, while exercising grounds of judicial review, maybe by the High Court or maybe by the Supreme Court, there are mainly three grounds of judicial review of administrative action. Number one, the number one ground of judicial review is illegality committed by the lower authorities. Second ground is irrationality committed by lower authorities. And third is procedural impropriety committed by the lower authorities. So on any of these three grounds, the power of judicial review can be exercised. Now let us see what are the modes of judicial review. The modes of judicial review of administrative action. There are mainly two modes of judicial review, that is public and private law review. Or in other words, you can say it, you can classify these two modes of judicial review as constitutional and unconstitutional mode of judicial review. Public law review here means a legislative enactment affecting the public at large. That means public law. It is a branch of law concerned with regulating the relations of individuals with the government and the organizations and the conduct of the government itself. And the subject matter of public law are constitutional law, administrative law, tax law, criminal law, and criminal procedure. Dear students, public law is a part of law that governs relationship between legal persons and a government, or between different institutions within a state, or between different branches of the government, and relationship between persons that are of direct concern to the society or public at large. Those laws are known as public laws, which affect the society or public at large. Whereas private law is concerned with relationship between private entities, individuals with one another, or relationship between citizens, companies, families, businesses, and small groups. that are not of public importance. The private law exists to assist citizens in disputes that involve private matters, and its scope is more specific than public law. For example, if you are filing a case under law of torts, or you are filing a case under Indian Contract Act, that governs the rights and obligations of persons entering into a contract. So that is a private law review, where you are filing a case under law of tort or law of contract. Whereas public law, as I told you, public law affects society as a whole, while private law affects only individuals, particular families, businesses, and small groups. And dear students, public law courts are like high courts of our country and Supreme Court, where remedy is awarded for violation of basic rights, whereas private courts are subordinate courts. I will highlight this portion. Private courts are subordinate courts, and the power of public law review is exercised by the Supreme Court under Article 32 or 136, special leave jurisdiction, and this power may be exercised by various high courts under Article 226 and 227 through writ jurisdiction. So in public law review, we have again 5 categories of writs, which we have already learned in previous lectures, and its abbreviation, as you know, is HMPQC. H stands for writ of habeas corpus, M stands for writ of mandamus, P stands for writ of prohibition, Q stands for writ of quo warranto, and C stands for writ of certiorari. So dear students, the public law review and private law review, these are the 2 kinds of judicial review. Private law review refers to the power of ordinary courts of the land exercised in accordance with ordinary laws of the land to control administrative actions. Private law review may be exercised through following modes. Number 1, by issue of injunction. You know, whenever a civil suit is filed, generally an stay application is also filed under Order 39, Rule 1 of CPC. And this is the requirement of Section 36 to 42 of Specific Relief Act also. Then you may file a suit for declaratory decree under Section 34 and 35 of Specific Relief Act, or you may file a suit for damages under Specific Relief Act. So all these are the examples of private law review. So dear students, this is all about regarding judicial review of administrative action in our country. Thank you very much.